All right, welcome again. Chapter 2 review here. Criminal Law Evidence Procedure, John Tyler Community College, summer 2017. We're looking at page 34 to start with on Chapter 2 here in Criminal Law and Evidence from Moore and Worrall. Starting in this chapter, we're going to start to break down some of the concepts of our authority here. So, what are some of the limitations? What are the authority that we have on criminal law here in the United States? The first thing we need to look at, especially terminology based, what kind of system are we in? We are in a federal system, right? We have divided powers. Not only do we have divided powers in our executive powers, our judicial powers, and our legislative powers, but we have a divided court system, right? We have state and local courts, right? We have a dual federal idea of how to let the states govern themselves and establish law, and how the federal system deals with federal means. It deals with interstate commerce, how the federal system deals with federal ideas and their laws and systems, right? You have to understand when looking at page 36 here, some of the ideas of the federal system's powers, some of the duties of the federal system, and then moving on to some of our limitations on criminal law on page 37, the principle of legality. Can't make a crime if it's not specific as to what the crime is. And we can't make something criminal if we don't define what the punishment might be for it. So it has to be codified, and it has to be clear and convincing, clear and equivocal as to what the act is that it's not allowed to be done, and what the punishment is for that act and why it's necessary. So when we talk about the principle of legality, like that first line says, it's often expressed through the Latin maxim, and forgive me if I mess this up: nullum criminum, nulla pena, and sinillage. So that translates into there is no crime without law, no punishment without law. Kind of makes sense, right? Moving on, the idea of lenity, it says a legal principle requiring that any ambiguity in a statute should benefit the defendant and not the government, right? We're here in the interest of the people, right? We are 50 states of people joined in a union to make a better nation, right? So when in doubt, the err to the side of caution, that whole idea of the principle of lenity. Module 2.2 here in Chapter 2 starts to talk about everybody's favorite constitutional amendments, right? Let's start with the Equal Protection Clause in the 14th Amendment. You'll notice that this is outside of the Bill of Rights. You'll notice that when we talk about the 14th Amendment, it was codified to protect everyone, right? To clear the misunderstanding, and make sure that it's understood that the U.S. Constitution, the Bill of Rights, all the rights afforded to us, in our legal system, protect everyone equally, right? The 14th Amendment requires the government to justify any differential treatment based on race, gender, age, sexual orientation, any other characteristic, any other protected class. We're here. Unfortunately, we had to make to get philosophical with it. It's unfortunately we even had to get to that point that we had to clear the air that all of our laws were meant for everyone. But the 14th is our equal protection, right? It's you, me, everyone who has citizenship, everyone who has their 2 feet on the ground in the United States shall be protected equally. Moving on to page 40 and 41, we need to look at some of the scrutiny in the equal protection cases. We need to look at what it means on our rational bias test, whether or not when we're talking about law and procedure, whether or not the law itself is an ex post facto law, is it punishing something retroactively? We couldn't say it's illegal to say the word the and then go and punish everybody who's ever said the word the before that, right? That would be an ex post facto law. So we can't do that, but that's part of the prohibition in that. Page 44 and 45 starts talking about some other protections from the Equal Protection Clause. Bill of Attainder, which is making a law that doesn't allow for a trial. Imagine if you lived in a system where you were locked up and thrown away the key, didn't have a chance to defend yourself, didn't have a chance to benefit from the system that we live in currently. Moving on to talking about the terminology in the base of void for vagueness. What does that mean? It's based in part in the 5th and the 14th Amendments ideas that laws, they have to be specific, right? They have to be sufficiently clear and sufficiently specific as to what the intent of the law is, what the act that's being made illegal, and what the punishment would be. So just like anything else, you wouldn't want to make a law that says, it's illegal to be bad, because what is bad? What is good, right? It would not be very clear. Think about an adult, a parent parenting a child, and you can't expect the child to change the behavior if you're not clear about what you don't want them to do, right? So same thing with this. Moving on. That leads into the ideas of victimless crimes. Leads into, do we legislate behavior that's not necessarily immoral, right? Look at the examples in the book of being a vagrant or loitering, think about the homeless, the idea of being homeless and whether or not it should be illegal to be homeless, right? A lot of people could argue that, they don't want homeless people panhandling in, their jurisdiction or their vicinity. Look at some of local Richmond, Virginia jurisdictions that tried to make laws prohibiting, vagrancy. But that's more of a law, trying to legislate people's belief systems as opposed to people's acts. So when we're talking about void for vagueness, when we're talking about the overreach of the government, we have to make sure that we understand, where do we draw the line as to where we're going to parent, where we're going to big brother, right? Where are we going to tell you that you can and can't lay your head, where you can't lay your foot, where you can't walk, where you can't be, right? If it's a public area, it's open to everybody. So think about a park bench. Anybody can sit on the park bench as long as the park is open, right? So why can't somebody take a nap on it? Why couldn't somebody eat their lunch on it, right? Same idea. Looking at page 48, it starts talking about the overbreadth doctrine, and, where laws start to infringe on constitutional behavior. The biggest one, and it's going to talk about it here, is our First Amendment right to free speech. So if it's codified that we are allowed to speak freely, when are we actually allowed to legislate speech? And some of the examples, they make sense, right? Speech is great. Everyone's entitled to their own opinion. Everyone is entitled to express themselves in the manner that they feel that they would like to. However, it makes sense as to why the government could infringe on your freedom of speech, and you can't go to a crowded theater. The old adage, yelling fire in a crowded theater. You can't yell fire in a crowded theater because that's going to incite a riot. It's going to incite, panic. It's going to cause more harm than your speech being allowed to say that. However, if you walk out into the middle of an open field somewhere and there's no one around, there's no crowd, there's no panic inducing in there, and you start yelling fire and it doesn't affect anybody, that speech is allowed, right? But it makes sense, right? And look at what's going on with terrorism and violent extremism currently, and what would happen in a major sporting event if someone started yelling that they had a bomb. Right, that speech itself, even if they didn't have a bomb, could cause so much harm to everyone else. Going back to the whole idea of the harm principle, that they are not allowed to do that. Right. Looking at some other things that are not protected of speech, the advocacy of riot and rebellion against active riot and rebellion against the government. That's called seditious speech. We all have heard about defamation. We've heard about libel and slander. What do each one of those mean? You need to make sure you understand the definitions of each one of those, so forth and so on. So keep on reading, keep on flipping here. Let's go through. I'm going to let you do your libel and your slander reading all on your own, so that we can hop on over into Module 2.3 real quick, and the idea of cruel and unusual punishment. Eighth Amendment, right? Eighth Amendment to the United States Constitution, cruel and unusual punishment, right? What does that mean? What does that normally come to mind when people start talking about that? Death penalty, right? That comes up right away. What is cruel and unusual? Is it cruel and unusual for a government to put someone to death? You need to be familiar with whether or not that's legal in Virginia, whether that's illegal in Virginia. That's probably a pretty good quiz question at some point. So, what do we mean by cruel and unusual punishment? What do we mean by how far we're allowed to go? Can you inflict corporal punishment on someone? You see in the United States justice system where people are getting caned and getting, physically attacked, or are we only talking about monetary fines and imprisonment and rehabilitation? What about if you were fined $1 million for speeding? Would that be cruel and unusual? Absolutely, right? Moving on to page 58 real quick, let's talk about sentence links. What if you were sentenced to a year in jail for running a stoplight? Does the punishment match the intent, or does the punishment match the crime? Right, same thing. What does double jeopardy mean? We hear double jeopardy all the time. What does it mean to be protected from being tried twice for the same crime? When can you actually be tried a second time? Looking at the Blockberger rule that talks about that on page 61. When does that double jeopardy not apply? Move on past that real quick and summarize this chapter, right? Hopefully it's starting to pique your interest and understand why you're taking this class, why it's important to know this in criminal justice, why we're setting these foundations so we can start talking about trial and evidence and whatnot. So good luck with your reading. Go through the rest of the PowerPoint, and good luck on the quiz.